Welcome to Law Made Simple, your trusted space for legal clarity. Today's episode tackles a question that's deceptively simple. Can you legally stop a check payment in India? It's a move many people make in panic or frustration. But what feels like a quick fix can lead to a criminal case. Stopping a check might feel like pressing pause, but legally, it could press play on a prosecution. We'll walk you through the law, the myths, and the mindset. You'll learn how courts interpret check stoppage, why some debts are enforceable and others aren't, how poor legal advice can backfire, and what steps you must take before signing that check. We'll also share real-world examples and preventive tips. Because legal literacy isn't just knowledge, it's protection. So grab your pen and paper, let's make law simple. And if you find this helpful, don't forget to like, share, and subscribe. Let's start with the legal backbone. Section 138 of the Negotiable Instruments Act, 1881 makes dishonor of a check, whether due to insufficient funds or stop payment, a criminal offense. Section 139 strengthens this by presuming the check was issued for a valid debt. This shifts the burden of proof onto the drawer, you. Section 142 allows courts to take action based on a written complaint and proper notice. So even if you stop payment, the legal process can still begin. Courts don't just look at the bank's response, they examine your intent, your conduct, and your documentation. Stopping payment doesn't erase your liability, it invites scrutiny. Even if you never intended to defraud, the law may still hold you accountable. The check is treated as a promise to pay, and breaking that promise has consequences. This isn't just about banking, it's about accountability. Understanding this legal framework is the first step toward responsible financial conduct. Let's now decode what makes a debt legally enforceable. Here's the key distinction: a legally enforceable debt is one that the law recognizes. It must be backed by consideration, something of value exchanged. A check issued for a business invoice, rent arrears, or a documented loan is enforceable. But a check given for a future gift, a casual promise, or a friendly loan without proof may not be. Courts look for evidence, agreements, delivery receipts, bank transfers, even WhatsApp messages. Even a signed acknowledgement or email trail can strengthen the case. If the debt lacks legal substance, you may have a defense. But if the debt is valid and documented, stopping payment won't protect you. Always ask, is this transaction backed by proof? Because in court, assumptions don't help, evidence does. This is where many people get trapped, thinking informal deals are safe. But once a check is issued, the law presumes intent to pay. Let's now explore how poor legal advice can lead you astray. Many accused are misled by lawyers who offer shortcuts. They're told, just stop the check, it's fine. Or, no written contract. They can't prove anything. But courts don't rely solely on paperwork. They consider chats, emails, voice notes, and even delivery photos. Some lawyers suggest delay tactics, hoping the complainant will give up. But delay often leads to harsher consequences. The longer you wait, the more credibility you lose. Check bounce is not just a civil issue, it's criminal. Choose lawyers who guide you with clarity, not shortcuts. Legal advice should protect you, not expose you. Misguided strategies often backfire, leading to conviction. And once a summons is issued, your options narrow. Always seek preventive, ethical legal advice. Let's now look at what precautions you must take before issuing a check. Prevention is better than litigation. Before issuing a check, pause and protect yourself. Is the transaction documented? Do you have proof of delivery or agreement? Can you explain the purpose of the check if questioned? Write the reason on the reverse side, it helps in court. Send a confirmation message to the payee. Keep a copy of the invoice or agreement. Even a simple screenshot or email can support your defense. These steps take minutes, but can save months of courtroom stress. Be proactive, not reactive. Because once the check is dishonored, the damage begins. Avoid issuing blank checks or post-dated ones without clarity. Clarify repayment terms if it's a loan. And always communicate clearly. Ambiguity invites trouble. Let's wrap up with key lessons. Stopping a check doesn't erase your liability. If the debt is enforceable, you're still accountable under Section 138. The law presumes you owe the money unless you prove otherwise. Don't rely on casual advice, understand your legal position. Document your transactions, communicate clearly, and act responsibly. Check bounce cases can affect your reputation, career, and peace of mind. Legal awareness is your best protection. Choose lawyers who guide you ethically, not tactically. Thanks for watching Law Made Simple. If this episode helped you, please like, share, and subscribe.